Let me ask you a couple questions. You think judicial activism, doctor, has hurt blacks. Judicial activism of eliminating restrictive covenants in deeds, eliminating segregation in schools, one man, one vote, literacy test. Do you consider those judicially active?
Well, as regards restrictive covenants, I can see no evidence that they did anything other than make some people feel good because it was symbolic. As regards desegregation of the school system, that should have been done long before and on a much more sound basis. I've gone into this at great length in previous writings.
But are they?
Problem with, no. You see, the problem is not whether you believe that school desegregation should have ended. I believe it should have ended long before.
Mm-hmm.
George Bork believes it should have ended long before. What he and what I have objected to are the principles used in that decision, because those principles take on a life of their own, and they come back to haunt you in other areas. Obviously, this old phrase, "the hard cases make bad law," derived from that fact. You dream up a principle to reach this result, and then the principle has a life of its own.
So the principle of desegregating the schools.
No, that wasn't the principle. The principle was the reason that they picked for it was.
Well, that's all I'm saying. Okay, the reasons they picked.
Yes.
Desegregating the schools, you and Judge Bork agree were the wrong principles, and they should have not. So the court shouldn't have done that.
No, the court should have done it.
Oh, okay.
Both of us have said the court should have done it.
I see.
And in my case, and I think in his case, the court should have done it a lot sooner.
How?
They should have ruled that it wasn't equal protection of the law, because nobody in his right mind believes that there was equal protection of the law in the Jim Crow era of these school systems.
I'm just trying to figure out what you're saying.
Yes.
Now, when they desegregated the D.C. schools, it's clear the 14th Amendment does not apply. Everyone agrees that the 14th Amendment does not apply to the District of Columbia. How would they have done it in the District of Columbia? Should they have just let it stand in the District of Columbia? Segregation?
No, in fact, Senator, it's interesting that you say that, because I've gotten the first thing I ever wrote on a public issue was in November 13th, 1950, in the Washington Star, in which I argued for the desegregation of the D.C. school system. So that
on what principle?
I had not studied nearly as much then as I have 37 years later, and so I hadn't worked it out. Nor do I think that I would want to work it out on the run in front of a large group of lawyers at this very moment in the time that's available.
Well, how about literacy test? Was it judicial?
I see no reason why people shouldn't be literate in order to vote. The question is, if you have a black who comes in with his degree from Harvard, and the man behind the desk says, "No, you're not literate, you can't vote," then this is what bothers me. People are talking about how judges should be sensitive to this particular group or that particular group. And if that means anything, if it means he's applying the law differently, that's precisely how blacks were held down for generations in the South.
I see. So literacy
applying the law differently.
So literacy test, as long as they were equally applied, are all right.
Sure.
So I thought you thought. Now, I also want to clarify. I gather from your comments about MIT and Harvard that you don't think there's enough blacks out there who are qualified to fill the number of vacancies allotted for them in those schools. Is that right? Is that what you're saying?
Well, the word qualified really is misleading.
Well,
the question is whether or not they are like the other students at Harvard and MIT.
Well, okay. Oh, so there's not.
So they may be perfectly qualified. This same student might go through, God help us, I hope there's nobody here from Illinois, Illinois Institute of Technology, and do well. But there's no reason why he should fail at MIT. There's no prestige in flunking out of the Ivy League.
I got it. So, but my point is, you believe there are not enough black women and men out there that are the same as white women and men to be able to go through Harvard and MIT.
If there were, it would mean that the whole history of oppression had done no harm whatever.
Well, so the answer is you don't think there are. I just want to figure out what you're saying.
It's not a question of what I think. It's a factual matter.
So factually, you're saying factually there are not enough.
Factually, this study's already been done by Klitgard at Harvard, and the figures are all there. Anyone can look them up.
Okay, no, I just want to hear from you. I want to know what you're thinking. Now, have you read all of Judge Bork's cases or any of them? Have you read all of his writings?
I haven't read all of them, but I've been reading them for more than 20 years because I used to teach antitrust economics.
Now, are you part of what they call the law and economics school? You know that. Would you consider yourself part of that school?
I
There's nothing wrong with that. It's not a bad school. I just wondered where you are.
When I sit down to write, Senator, I don't ask what my label. I don't check my identification tag to see what I am. But
Well,
I did. One of my books did win a prize as the best book in law and economics in 1980.
yeah, no, but I mean, there's almost a term of art out there called the School of Law and Economics.
Yes,
And are you part of that school intellectually? That's all I'm trying to get.
I'm very much interested in the application of economic principles in the law and vice versa.
Right. Now, my time's up. Thank you very much.